Andreas is now in session. The Honorable Justice Granny Noonan presiding.
Good morning, dearies.
Good morning, Your Honor.
Thank you for coming, dear, this morning. I hope everyone has had a good breakfast. Yes?
Yes, ma'am.
Yep.
If not, dear, Mac here can hand out my cookies. Woo!
Yeah, boy.
Okay, dear, we are here to hear the appeal of the state of San Andreas versus Richard Anderson. Each side will have 15 minutes, uninterrupted, unless I interrupt you. Okay, dear? You may go longer than 15 minutes if I ask you questions. Mr. Hogginson, please proceed.
Your Honor,
Yes, dear, that is me.
sorry, I am just looking over this to find out where to start. I apologize.
Are you not ready, dear?
Yes, I can do what I can, I guess. Originally on the docket, there was an error to one of the charges, which was PC 2319, conspiracy to commit a state felony. It was meant to be PC 1131, conspiracy to commit a federal felony. The Honorable Morales also reversed the decision to approve a case dismissed with prejudice due to the motion by Mr. Hunt and Mr. Hall that Mr. Anderson was only being charged with conspiracy to commit a murder, whereas the charge itself was first-degree felony murder. Give me 1 second to find it.
Excuse me, Your Honor.
Okay. PC 2101, first-degree murder of a peace officer. Where Mr. Hunt and Mr. Hall saw that he wasn't being charged with murder at all, I do not know, but the motion was accepted or approved, and I do not know why. Hence, we are here in appeal to go back to court to try the suspect for both charges. That's all I have, Your Honor.
So what are you charging him, dear?
We would like to charge him with PC 1131, conspiracy to commit federal felony, and PC 2101, first-degree murder of a peace officer.
So, dear, are you saying that he has conspired to commit the murder, or he committed the murder, dear? Which one are you saying here?
He committed the murder, and the evidence shows he conspired to commit other felonies.
So you're saying the conspiracy is a separate charge, dear?
I believe so, Your Honor.
You believe so, dear, or you know? Your office is bringing these charges, correct, dear?
Yes, Your Honor.
Okay, so what are you charging him with and why? It is your 15 minutes, dear, so you have...
I understand this, Your Honor. We have testimony from the late Juliet Pierce, which was accepted into evidence, stating conspiracy to commit many felonies with the gang he was involved with. And he also committed murder, Your Honor. So both charges.
What is the other charge, dear? What did he conspire? What was he conspiring to do?
I do know there was kidnap, attempted murder.
Why wasn't that listed, dear?
I did not raise the docket, Your Honor. I'm taking this up from prosecution that has fallen ill.
Okay, dear. Okay.
I'm not 100% on this case. I just know which part we are appealing on.
Okay, dear.
Excuse me.
So, just verifying, you are charging him with murder,
Yes,
and you
ma'am.
are charging him with conspiracy to commit other crime, correct?
Yes, ma'am. Yes, Your Honor.
And you're saying that there is an error in filing, and you said it was a state felony instead of a federal felony, dear. Is that what you are saying?
Yes, Your Honor.
Okay, dear.
Also, that the previous judge dismissed the case for attempted murder, not, or conspiracy to commit murder, not actual murder, when the charge was murder.
Okay, dear. Does the state have anything else, dear? You need another minute. It is your 15.
That's all I have, Your Honor.
Okay, dear. Councilors Hall and Hunt. You have
Good
the floor,
afternoon,
dear.
Your Honor. Well, I think there's a couple things that we should clarify. It was stated.
Please speak loud, dear.
You able to hear me, Your Honor?
No, dear.
Oh,
I am having trouble. I am an old woman, dear.
is that better?
That will do.
Okay. I think there's a couple things that should be clarified. It was to the court's understanding and our understanding that the defendant was being charged with conspiracy to commit murder. It was never once stated that the defendant was being charged with separate crimes. And I'll raise a couple things with regard to this. Let's say in this scenario that he was being charged with conspiracy. In the conspiracy charge, it states that you must add the charge that they conspired to commit as a separate charge. So you can't just go and say to the court, hey, look, we're charging with conspiracy to commit kidnapping, attempted murder, all this. You have to add it as a separate charge. And in this case, what the prosecutor who actually filed the case, they charged them with conspiracy to commit a state felony and then conspiracy to commit the murder. And that's what he was being charged with. And I'll raise a couple points that were mentioned in their brief because I recognize Mr. Hogginson wasn't on the case, so I'll do my best to address what the prosecutor raised in his brief. But before I start, I think that this court must only look at what was raised in the brief and what was raised in the argument. And to talk about briefly what was mentioned in the brief, that it was ruled and that there was no error. So they're essentially stating that the error was on part of the state, but the judge made an error in not looking over the criminal code. I would state that the court makes a ruling on the information that they have. And the information that they had was that the defendant was being charged with conspiracy to commit a state felony. At no point in the docket did the prosecutor or the state ever try to amend the charges. Did they never state that it was an error? That's only now being mentioned in the brief. And I would state that the appeals court should look at whether or not the presiding judge made an error with the information that they had at them at the time. I don't think they should have to look through all this and that. This appeals court should only look on whether or not the presiding judge made an error with the information that was presented to them. And to that point, the presiding judge asked for a rebuttal from the state. The state did not provide a rebuttal. And I believe it went on so forth to Judge Morales actually requesting it from the prosecutor in person. And again, the state did not provide a rebuttal. With regard to the third point that they stated, I'm sorry, let me just ensure that I'm not misquoting the prosecutor. The prosecutor in his brief stated, the Honorable Morales failed to consider the seriousness of the offense, the circumstances leading to the dismissal, and the impact that reprosecution would have on the administration of the act and on the administration of justice. I think it's important to make a brief clarification here. When the motion to dismiss was submitted, it was not submitted on the grounds of the Speedy Trial Act. It was submitted on the grounds of the statute of limitations. And in explicitly what he stated, it states the administration on the act. And we did not submit the motion to dismiss on the grounds of the act. It was based on the fact that the statute of limitations was already violated. It was, I think it was, we were getting near the 60-day mark of him being
So,
without
dear,
indictment.
just to understand, you are saying that the prosecution is only charging them, or to your knowledge, was only charging them with the conspiracy to commit murder. Is that correct?
That's what the prosecutor had told us, yes.
Okay, dear, carry on.
And again, to that point, I do not think that this court should rule in favor of the fact do the state made an error, because the judge didn't make an error in his ruling. Whether or not the judge made an error should be determined on the fact of, again, the information that they have provided to them at the time. And the information that they have presented to them was that he was being charged with conspiracy to commit a state felony. Just want to ensure that I touched on everything, especially what was raised inside the brief from Mr. Hogginson. Right. So I guess I can open up to any questions, but to just conclude, the state is asking the court to reverse the state court's judgment because they made an error. And we'd submit to this court that this court should look at whether or not the judge made an error with the information that they had at the time. And with the information they had, again, it was conspiracy to commit a state felony. Your Honor, if you have any questions, I'm happy to answer them.
No, dear, I think I have everything I need.
I believe I just have
Mr.
one
Hall,
more
one.
point, Your Honor.
Go ahead, dear.
Now, in this case, it
I
seemed like
can't
the...
hear you, dear. Step
Oh,
a little closer.
Yeah, I can try and step closer for you.
That is good, dear.
All right. Now, it seems that the main point of contention in this case is essentially whether or not the charges that were brought did have a statute of limitations. That's at least the perception that the respondents were getting. Now, specifically in the statute of limitations in the criminal code, there are a multitude of different statute of limitations laws, but they're... Sorry, give me one moment.
Are you okay, dear?
I apologize, yes. So I'd like if the court could reference under the criminal code, it's going to be section 19, federal crimes. Now, the respondents would also contend that the appellants don't actually have standing in terms of bringing this appeal or the case in question. Specifically under the section 19 of the criminal code, only the Attorney General's office can bring federal charges and press federal charges against a defendant. Since the district attorney's office...
Dear, repeat that for me, dear.
Of course. Specifically underlined under section 19 of the criminal code. This is the section labeled federal crimes. It specifically states by law that the Attorney General's office is the only prosecuting body that is able to press federal crimes. So we'd contend that the appellants do not have standing in terms of bringing criminal charges against the defendant.
Dear, I will not hear this much further, dear. Okay. The only thing we have in this city is the DA's office, and that is what will be going forward, dear. Do you understand?
I do understand, Your Honor.
So, dear, in that regard, if you have anything else to say that doesn't involve that line of argument, please continue, dear.
Of course. Now, specifically cited was the fact that murder per se does not have a statute of limitations. Of course, the respondents would argue that that is incorrect. In terms of, in any sort of state, for any specific charge to not have a statute of limitations, it must be outlined by law. And specifically, nowhere in any of the statute of limitations acts does it specifically define that murder is an exception to the statute of limitations. So the respondents would contend that because...
What?
I'm sorry, Your Honor, there's nothing further from the respondent.
Okay, dearies.
Okay.
I have everything I need. I have no further questions. This will not be decided now. You should see my write-up on this later today. Okay, dear?
Thank you. Your
Thank
Honor.
you, Your Honor.
Court is adjourned.